Good day, ladies and gentlemen, and welcome back to another What If video. For those of you who don't know me, my name is Viapia, and today's topic is what if an employee's misconduct was as a result of mental health issues. Now, if we can just imagine the following. We sit in a disciplinary hearing, an employee has been charged with misconduct, and in the disciplinary hearing, the employee argues, and let's say they submit medical proof that the misconduct was as a result of a mental health issue or a mental illness. Now, we have seen in the last couple of years an increase in cases being heard by the CCMA and Labour Courts regarding employees and mental health. And those of you who have followed our videos would know that last year we posted a video on the matter between Legal Aid and Janssen, where Mr. Janssen unsuccessfully argued that his dismissal was automatically unfair because, according to him, the reason for his dismissal was not his misconduct, but the fact that he suffered or suffers from depression. So you can go onto our Facebook page or our YouTube channel and find the video on Legal Aid versus Janssen. But today's matter is similar. However, in this case, the question was not whether the dismissal was automatically unfair. It's just the question of what impact can a mental health issue have on the substantive fairness of a dismissal. Now, in unpacking today's topic, I will be referring to the case of Mr. Palanga and his previous employer, Petro Oil Gas Corporation of South Africa, probably better known as Petro SA. So, in this matter, it's a new case. I think judgment came out in July this year. So in this matter, the employee was charged with misconduct for being absent for 4 or more days without a valid reason. At the time of the hearing, the employee did not have a great disciplinary record. He had previous transgressions relating to punctuality, unauthorized absence, fraud, and negligence. At the disciplinary hearing, the employee pleaded guilty, which is interesting. But in mitigation, he made statements and unfavorable allegations against his employer, and he said, and this is important, that the reason for his absenteeism was because he felt trapped and sought to avoid psychological breakdown or brain paralysis. The chairperson of the hearing ruled that the report of a clinical psychologist must be considered before the hearing can be concluded. The report was then received, but importantly, it did not address whether any psychological issues were affecting the employee's behavior. The employee was then dismissed. Post-dismissal, the employee referred an unfair dismissal dispute to the National Bargaining Council for the Chemical Industry, and the arbitrator found the dismissal procedurally unfair but substantively fair. Although the procedural unfairness were not challenged by the employer, it related to the employee being essentially suspended without pay pending the conclusion of the hearing. So after the hearing, the adjournment thereof or the postponement thereof, there was a period where they were waiting for this medical report or evidence, and the employee was not paid during that period. The employee was not happy with the the substantive fairness as was decided by the commissioner or the arbitrator, and therefore he took the matter on review. In the Labour Court, the employee argued, in summary, the following: that an employer has a duty to investigate the impact of a real possibility of ill health on the employment relationship, and further, where there is such a possibility, the investigation must be completed and any contemplated disciplinary steps held in abeyance until that investigation is done. The employer argued that if the outcome of this investigation indicates that the situation can be remedied through some form of treatment, that intervention should be undertaken first. Consequently, the employee's argument means that an employer must prove that incapacity is not the reason for the employee's behavior or his misconduct in circumstances where it might possibly explain it before the employer can dismiss the employee for misconduct. So the employer must prove before you can dismiss the employee for misconduct that incapacity is not the reason for the behavior. So that was the employee's arguments. Essentially, Petro SA disagreed with that and they argued otherwise. But I'm going to focus on what the court then said, what the judge in this matter said. The court held the following. The first point that needs to be made is that it is trite that an employer bears the onus of justifying the fairness of a dismissal on the basis of the reason given for the dismissal. Remember, when we talk about reason for dismissal, we refer to 3 grounds: misconduct, incapacity, or operational requirements. In this case, the reason for the dismissal is misconduct. Now, whilst these categories of legitimate reason can sometimes become blurred, the employer must defend the dismissal on the basis of the reason it provides for the said dismissal. If an employee charged with misconduct believes that their actions can be explained as something beyond their control because they are suffering from a physical or mental incapacity, the employee can lead evidence to show that they are not at fault, or that the degree of fault is diminished by their condition and it warrants the adoption of other measures before dismissal can be justified. So importantly here, the court said that the employee can lead evidence. The employer has charged the employee with misconduct. If the employee believes that the misconduct was as a result of something beyond their control because of physical or mental incapacity, they can lead evidence to show that they are not at fault. The court also held that the employer is not obliged to eliminate all possible explanations for what appears to be the deliberate and willful misconduct of an employee in circumstances where other possible explanations were not previously known to the employer or were not obviously apparent. In this regard, the principle that an employer should exhaust all possible alternatives to dismissal must be contextualized. In other words, if the employer was not aware of any possible incapacity, how can the employer be expected to consider incapacity before charging an employee with misconduct? In this case, the employee had the opportunity to pursue the possibility of obtaining a clear psychological diagnosis provided by the investigation. He also had the opportunity of advancing psychological reasons as a defense to the charge of misconduct and leading evidence in support thereof. But he did not do this. Instead, he attempted to place the ball in the employer's court because the employer had contemplated the mere possibility of a different sort of inquiry, referring back to the chairperson and the chairperson directing the hearing to obtain more evidence on this possible incapacity. The court then concluded that the arbitrator did not commit any reviewable irregularity and that the outcome was one that a reasonable arbitrator could have reached on the evidence before him. The court accordingly confirmed that the dismissal of the employee was substantively fair. Now, just to end off, we need to look at what is the importance of this judgment for employers. The importance, ladies and gentlemen, is that employees charged with misconduct have an obligation to prove that their mental health played a role in their misconduct, especially, and this is important, especially when an employer was not previously aware of such incapacity. However, the case would have been different had the employer known of the possibility that the misconduct could have been as a result of incapacity. Employers must, however, take note that issues of mental health should be taken seriously in the workplace, and if the employer had reason to believe that the incapacity is indicated based on long-term or persistent absenteeism of an employee, then there's an obligation in terms of the Code of Good Practice to investigate this and to implement the guidelines as set out in the code, including, this was the employee's argument, considering all alternatives short of dismissal to address the situation. However, as we have mentioned above, the mere possibility of an ill health issue raised by an employee during misconduct proceedings, including the hearing or arbitration, does not place such an obligation on the employer. The onus of proof is on the employee to substantiate their defense to the misconduct charges. That then brings us to the end of this video. Should you require any assistance in this regard, or maybe you are dealing with a similar case, please do not hesitate to contact us. I hope to see you soon, but until next time, bye-bye.